With artificial intelligence on a meteoric rise, public and politicians alike are questioning how it's going to impact things like safety, intellectual property, and so much more. The UK has positioned itself as having a pro-innovation approach with no dedicated legislation regulating AI. But a recent report from the Parliamentary Office of Science and Technology has outlined a few of the steps that could be taken if that needed to change. So in this video we're breaking down those steps to understand what they are, why they might be needed, and why some of them might prove controversial. To understand what the future of AI regulation holds, we first need to understand what the state of play is now around the world. The EU is currently finalising an AI Act that will work in tandem with other pieces of EU legislation, such as General Data Protection, GDPR. The Act defines different risk levels with corresponding regulation, and goes as far as to ban certain high-risk applications. Meanwhile, over in the United States, a blueprint for an AI Bill of Rights has been outlined. Non-binding guidelines aiming to tackle discrimination, data privacy, and transparency. President Biden has also signed an executive order on AI, mandating standards and disclosures for the largest AI companies. Over in the UK, however, things look a little different. In March 2023, the UK government announced a pro-innovation approach to AI regulation. What does this look like, you may ask? Well, that there is no dedicated AI legislation in the UK. Instead, the UK will rely on its existing laws like the Data Protection Act, Equality Act, and Copyright, Designs and Patents Act to uphold some common principles. Safety, security and robustness, appropriate transparency and explainability, fairness, accountability and governance, and contestability and redress, liability. Now, this approach doesn't necessarily make the UK complacent. In November 2023, Prime Minister Rishi Sunak hosted an AI Safety Summit, where, as well as Sunak chatting with Elon Musk, a declaration for AI safety was signed by 28 countries, and an AI Safety Institute was established. We can tell from this that the UK is very conscious of AI, and maybe all of this goodwill is enough. Maybe the laws the UK already have will be sufficient, or maybe they won't be. After all, the capabilities of AI are developing at a rapid pace. It's a technology that's rapidly changing how we work, how we learn, and what we consider to be ownership. So given all that, let's suppose that down the line the UK decides to change its mind. What problems would be so prolific so as to cause that change of heart? What regulation would be introduced, and who stands to gain or lose from that? We might have some answers. The UK's Parliamentary Office of Science and Technology recently released a report outlining 6 potential measures that stakeholders suggested could be adopted as regulations. So, one by one, let's dig into them. Number 1. Human intervention in automated decision-making. Who is responsible for automated decisions made by AI? Who could carry the liability for the consequences of those decisions? It's the difficulty of answering these questions, be it for self-driving cars or for automated medical diagnoses, that has prompted ideas of a right to human intervention in automated decision-making. Now, there are 2 ways to go about this. The first option is that all major automated decisions would be subject to human review, which, although some legal scholars say is necessary so that a human can bear liability, others point out that this would reduce the efficiency gains of automated decision-making in the first place. Alternatively, the second option is that only contested decisions would be subject to human review. This would solve the efficiency problem, and might be considered sufficient to address any ethical concerns. However, some worry that a lack of transparency may make it less likely that certain people, such as those from digitally excluded communities, would be subject to a fair decision. Now, on the flip side, there are some calls to ban automated decision-making altogether, citing that it's not compatible with societal values such as equality and fairness, and that it can infer intimate knowledge about humans. Of course, the UK's pro-innovation approach makes this course of action quite unlikely, but it is something to think about. Number 2. Algorithmic impact assessment and audits. In the UK, existing data protection legislation ensures that data controllers assess their processes for anything likely to result in a high risk to the rights and freedoms of individuals. Algorithmic impact assessments would be similarly motivated, defending rights and freedoms, and could be modelled on data protection. If so, they would involve describing the AI systems and processes, assessing the potential impact of AI processes on people's rights and freedoms, measures to address those risks, and safeguards and mechanisms to ensure compliance with regulations. There is a precedent for this elsewhere in the world. In Canada, government agencies are required to complete a questionnaire before deploying automated decision-making. Now, aside from a little extra administrative work, this approach really doesn't have any major downsides. In fact, auditing is something that the UK's Digital Regulation Cooperation Forum, made up of these groups, is currently exploring the future of. So this one might actually be quite likely. Number 3. Banning live facial recognition. This has been something that has been called for in the UK on the grounds that the EU are already doing it. This because it can have a real impact on civil liberties, privacy, and right to protest, and perceived impacts, as individuals may restrict their freedom of expression and what they do because of an atmosphere of surveillance. However, both the Metropolitan Police and Home Office have defended the use of the tech, claiming it has already enabled a large number of serious criminals to be caught. With the Metropolitan Police adding that it saves police officers time, helps identify criminals, and safeguards vulnerable people. So as a result of that, banning live facial recognition won't be an easy choice for the UK to make. Number 4. Open access to underlying code and related documentation. If you want total transparency on how an automated decision has been made, how better than to have the models and the documentation for them open to the public. Be useful for you, and it could be useful for small businesses wanting to develop their own models, which would promote competition in the sector. A good thing. Now, to some extent, this is happening already. Both Meta and Mozilla have already started sharing some elements voluntarily. Others, though, like OpenAI, who are behind ChatGPT, have argued against such measures, over safety concerns, that what they share could be used for malicious purposes. By now you can probably see the trend that no one can quite agree. Number 5. Opt-in and opt-out datasets. Generative AI, which writes text or creates images or other forms of media, works by being trained on massive datasets. But a conflict arises when the outputs of this AI mimic the style of a human creator whose work might be in that original training dataset. It raises questions over intellectual property rights, and in some ongoing court cases, it's been alleged that outputs that mimic or interpret a specific style of a human creator who didn't consent to having their work put into an original dataset is actually an infringement of that creator's copyright. Now, to resolve this going forward, an opt-in or opt-out model would give creatives greater control over whether they're included in datasets. An opt-in model would prioritize creators, with them having to consent to their inclusion in datasets. However, the issue with this is that it would hamper the development of AI, as there would probably be low uptake of the opting in. In contrast, an opt-out model would automatically allow for expansive datasets, but it would increase the administrative burden on rights holders and developers in requesting and resolving opt-out requests. Finally, number 6, regulatory capacity and funding. This is an approach that would tackle AI as a whole, addressing all of the issues we've already talked about in this video and many more that we couldn't even get to. The idea is to set up a legislative central resource of expertise on AI that other regulatory bodies could consult with. In the UK, it's been recommended that the aforementioned Digital Regulation Cooperation Forum could see its role expanded to be that expertise centre, and that other regulators could join to access those resources. However, there are concerns over how well this could be done. Some suggest that there isn't enough staffing, funding, or expertise to regulate AI so that current laws are enforced, let alone any of the potential new ones that we've just talked about. But looking over everything, a central expertise hub probably isn't a bad idea. How each of these suggestions are potentially developed and implemented is going to need careful consideration. The rapid advancement of what AI is capable of means that its policy implications are constantly changing. It's probably good that the UK is positioning itself as a major advocate for its innovation first, but ultimately safe and principled development. That said, now you know the options that the UK and the rest of the world has to regulate AI if the time comes. Thanks for watching this episode of Science Affairs. If you've made it this far, then be sure to like the video and subscribe if you haven't already. See you in the next one.